December 9th, 1946. 23 German physicians and medical administrators sit in a Nuremberg courtroom. These are not common criminals. These are respected doctors, scientists, university professors, men with medical degrees from prestigious institutions, men who believe they have a defense. They followed orders. They acted in wartime. Other nations conducted similar experiments. They were advancing medical science. They're confident that professional status and legal precedent will protect them. August 20th, 1947. 7 of those doctors are sentenced to death by hanging. 9 more receive prison terms ranging from 10 years to life. Their names become synonymous with medical atrocity. The trial produces the Nuremberg Code, 10 principles of medical ethics that explicitly condemn everything they did. Their defense, the strategy they believed would save them, collapsed so completely that it changed medical law forever. What happened between those 2 moments? This wasn't bad lawyering. It wasn't biased judges. It wasn't even the horror of the crimes themselves, though those were unspeakable. This was a systematic failure of legal and moral reasoning on a scale these physicians never anticipated. Between December 1946 and August 1947, every defensive argument they raised, each one more desperate than the last, was dismantled by evidence, testimony, and legal principles they had fundamentally misunderstood. Today, I'm going to show you exactly how the most confident medical defense in history destroyed itself. Not through lack of preparation, but through a series of miscalculations so profound that conviction became virtually inevitable. And here's what you need to understand before we begin. These weren't random mistakes. They were connected. Each defensive failure made the next one harder to avoid. Each miscalculation put the defendants in a weaker position for the next legal argument. By mid-1947, these doctors were locked into a trajectory that could only end in condemnation. So the question isn't whether the Nazi doctors were convicted. The question is, could their defense strategy ever have succeeded, or was it doomed from the moment they walked into that courtroom? Stay with me, because by the end of this analysis, you'll understand why the answer is more revealing than you might expect. But first, we need to talk about the single greatest legal miscalculation in the entire trial. Before we dive in, if you're interested in deep dive historical analysis of wartime trials and the evolution of international law using primary sources and court documents, I'd really appreciate if you'd hit that subscribe button. It helps the channel grow and lets me know you want more content like this. And as we go through these defensive blunders, drop a comment telling me which one you think sealed their fate most decisively. I read every comment and I'm genuinely curious what you think. All right, let's get into it. December 1946. The American Military Tribunal opens criminal proceedings against 23 defendants. The charges are devastating. War crimes, crimes against humanity, membership in criminal organizations. The specific allegations involve medical experiments conducted without consent on concentration camp prisoners, freezing experiments, high-altitude experiments, malaria experiments, sulfanilamide experiments, experiments involving poison, incendiary bombs, and seawater. The defense team has a strategy. It's built on a principle that worked in civilian criminal courts across the world for generations. Superior orders. The idea is straightforward. These doctors were following commands from their superiors in the Nazi state. They were obeying lawful orders in wartime. Individual physicians cannot be held criminally responsible for actions taken under state authority. It sounds reasonable. It has legal precedent. The defense team believes this argument will create reasonable doubt, perhaps even secure acquittals. Here's what they didn't know. The superior order's defense had already been rejected. Not at this trial, before this trial even began. At the main Nuremberg trial of major war criminals, which concluded in October 1946, 2 months before the doctor's trial opened, the International Military Tribunal had ruled explicitly on this question. Superior orders could be considered in mitigation of sentence, but not as a complete defense to war crimes or crimes against humanity. The legal framework had changed. The doctors and their attorneys were preparing arguments for a world that no longer existed. But there's something even more fundamental they missed. During the trial, prosecution witness Dr. Werner Leibbrandt, who had worked in the Reich Ministry for the occupied Eastern Territories, was cross-examined by defense lawyers. They asked him directly whether physicians must comply with superior orders for the common good of the state. His answer was unequivocal. The state may order physicians to conduct experiments, but physicians remain accountable for their actions. This wasn't an Allied prosecutor speaking. This was a German medical official, testifying under oath that professional medical ethics transcend state authority. The defense had assumed that German medical culture would support obedience to state power. Instead, their own witness contradicted the central pillar of their defense. The superior orders argument collapsed, not because the tribunal was biased, but because the defense had fundamentally misread both the legal landscape and the ethical standards of the medical profession itself. And that failure led directly to the next miscalculation. Because if following orders wasn't a defense, maybe proving that other nations did the same thing would be. The defense team pivoted to a new strategy. It's called tu quoque in Latin. You did it too. If the prosecution was going to condemn German doctors for conducting experiments without consent, the defense would show that Allied nations did exactly the same thing. And they had examples, real ones. Defense attorneys presented evidence that France, Holland, Great Britain, and the United States had used prisoners as experimental subjects in dangerous medical research without obtaining voluntary consent. American prison experiments, British military trials of vaccines, French colonial medical research, these weren't fabrications. These experiments actually happened. The defense argument was simple. If civilized Allied nations conducted similar experiments, then German doctors were merely following an unwritten international standard of medical practice. You can't condemn us for doing what you yourselves have done. It sounds like a strong argument. It appeals to fairness. It suggests hypocrisy in the prosecution. There was a problem, a massive problem that the defense completely failed to anticipate. The problem was scale. And the problem was consent. And the problem was something the defense attorneys had completely overlooked. Yes, Allied nations had conducted experiments on prisoners, but those experiments were fundamentally different in three critical ways. First, scale. American prison experiments involved dozens or hundreds of volunteers, not hundreds of thousands of victims. Second, mortality. Allied experiments rarely resulted in death. German experiments killed thousands. Third, and most damaging to the defense, the Allied experiments, however ethically questionable, still operated within some framework of voluntary participation, even if that framework was compromised by coercion. The German experiments involved no consent whatsoever. Concentration camp prisoners were selected. They were not asked. They were not volunteers. They were subjected to procedures designed to kill them or cause permanent harm, often explicitly for that purpose. The prosecution's response to the tu quoque defense was devastating. Chief Prosecutor Brigadier General Telford Taylor addressed it directly in court. His argument was simple and legally unassailable. Even if Allied nations had committed similar crimes, and he did not concede that they had, that would not excuse the defendants. Two wrongs don't make a right. Criminal guilt is individual, not comparative. The tribunal agreed. The tu quoque defense was rejected, not on procedural grounds, but on moral and legal principle. The fact that others may have committed crimes does not absolve you of your own crimes. And with that rejection, the defense lost its second major argument. Following orders didn't work. Pointing to Allied conduct didn't work. So the defense shifted again, this time to a claim that seems almost incomprehensible in hindsight. They argued the experiments were medically necessary. This is where the defense strategy began to collapse under the weight of its own contradictions. Because to claim medical necessity, they had to admit the experiments happened. And once they admitted that, the documentary evidence became their executioner. Let me show you what I mean. The prosecution presented nearly 1,500 documents during the trial. These weren't Allied intelligence summaries or secondhand reports. These were German documents, official records, memoranda, experimental protocols, reports written by the defendants themselves. Take the freezing experiments conducted at Dachau. Dr. Sigmund Rascher, working under the authority of Reichsfuhrer SS Heinrich Himmler, conducted experiments to determine how long German pilots could survive in freezing water after being shot down over the North Sea. The experiments involved submerging concentration camp prisoners in ice water and monitoring their decline toward death. The defense argued these experiments served a legitimate military medical purpose, aiding the survival of German airmen. Here's the problem. Rascher's own reports, submitted as evidence by the prosecution, described the experiments in clinical detail. Subjects screaming, subjects begging for death, subjects losing consciousness, body temperatures dropping to fatal levels. Many subjects died during the experiments. The documents didn't just prove the experiments happened, they proved the defendants knew exactly what they were doing. They proved premeditation. They proved systematic planning. They proved that the suffering was observed, recorded, and continued anyway. And here's what the defense failed to anticipate. When you claim medical necessity, you invite scrutiny of the medical value of the work. The prosecution brought in expert medical witnesses who testified that the experiments were scientifically worthless. The methodologies were flawed. The data was unreliable. The conclusions were invalid. So the experiments weren't just criminal, they were also bad science. They served no legitimate medical purpose because they produced no usable medical knowledge. The medical necessity defense imploded, and now the tribunal had something even more damaging than witness testimony. They had the defendant's own signatures on documents ordering atrocities. Documents like the one signed by defendant Karl Brandt, Hitler's personal physician, authorizing the killing of children deemed unworthy of life. Documents signed by defendant Victor Brack, authorizing sterilization experiments on concentration camp prisoners. Documents signed by defendant Wolfram Sievers, ordering the creation of a Jewish skeleton collection that required murdering 112 people and defleshing their bodies for anatomical study. These weren't forged. The defendants didn't even claim they were forged. They were authentic German military and medical records, filed in official archives, stamped with official seals. Every document the defense tried to use to prove medical legitimacy became evidence of criminal intent. Every signature became proof of participation. Every report became a confession. And then the prosecution did something the defense had not prepared for. They brought the victims into the courtroom. 85 witnesses testified during the trial. Many of them were survivors. People who had been subjected to the experiments and lived to describe them, Polish women who had been subjected to sulfanilamide, experiments at Ravensbrück concentration camp, experiments that involved deliberately infecting wounds to test experimental drugs, survivors of freezing experiments, survivors of high-altitude experiments, survivors of sterilization experiments. These were not abstract legal arguments. These were human beings standing in front of the judges, showing scars, describing what had been done to them. The defense strategy had no effective counter to this. How do you cross-examine a survivor who shows physical evidence of what was done to her? How do you challenge testimony when the witness can point to her own body as proof? The defense tried. They attempted to discredit witnesses by suggesting their memories were unreliable or that they were exaggerating. It backfired. The tribunal found the survivor testimony credible, consistent, and corroborated by the documentary evidence. But there was another defensive miscalculation that might have been even more fatal. The defendants believed their professional status would protect them. These were not street thugs. These were university-educated physicians. Men like Karl Brandt, who held the title of Reichskommissar for Health and Sanitation, one of the highest medical positions in Germany. Men like Dr. Karl Gebhardt, personal physician to Heinrich Himmler and president of the German Red Cross. Men like Dr. Gerhard Rose, a tropical disease specialist with international recognition. They believed their credentials mattered. They believed the tribunal would see them as colleagues, as fellow men of science who had made difficult decisions in wartime. They believed professional courtesy and respect for medical expertise would create sympathy. They were wrong, catastrophically wrong. The prosecution understood something the defense did not. Professional status made the crimes worse, not better. A physician swears an oath to do no harm. The Hippocratic tradition, which every defendant would have studied, explicitly forbids using medical knowledge to cause suffering. When a trained doctor uses that knowledge to torture and kill, he hasn't just violated the law, he's violated the fundamental ethical core of his profession. The tribunal saw it the same way. Professional medical training wasn't a mitigating factor. It was an aggravating factor. These men knew better. They had the education to understand what they were doing. They had the ethical framework to recognize it as wrong. They did it anyway. And here's where the prosecution made a brilliant strategic move. They didn't just rely on lawyers and judges to make this point. They brought in their own medical experts. Doctors who could speak as peers of the defendants and condemn them from within the profession itself. Dr. Andrew Ivy, one of America's leading physiologists, served as the chief medical expert for the prosecution. Dr. Leo Alexander, a psychiatrist and neurologist, served as medical investigator and consultant. Both were Hippocratic physicians. Both took the stand and testified that the experiments violated every principle of medical ethics. The defense tried to cross-examine them. They tried to show that American medical research involved ethical compromises too. Dr. Ivy was asked directly about American prison experiments. His response was devastating. He acknowledged that such research existed, but emphasized the critical difference: voluntary consent. American prisoners could refuse. Concentration camp victims could not. The defendants' professional status, which they thought would be their shield, became their executioner's axe. The tribunal concluded that their medical training made them more culpable, not less. But the defense made another miscalculation that might have been even more fundamental. They misunderstood who was judging them and what legal principles would govern the trial. The doctor's trial was not a German court. It was not bound by German law. It was an American military tribunal operating under international legal principles that the defendants and their lawyers didn't fully comprehend. The judges were American, 4 military judges, each one a lawyer with experience in military law. Presiding Judge Walter Beals, a former judge of the Washington State Supreme Court. Judge Harold Sebring, former justice of the Florida Supreme Court. Judge Johnson Crawford, former Oklahoma District Court judge. Alternate Judge Robert Toms, former Michigan Circuit Court judge. These were not European jurists steeped in continental legal tradition. These were American judges applying American legal reasoning to international crimes. The defense prepared arguments based on assumptions about European legal culture, about deference to state authority, about the relationship between medicine and government. Those assumptions were irrelevant. The tribunal operated under a completely different framework. The London Charter, which established the legal basis for the Nuremberg trials, had created a new category of crime: crimes against humanity, acts committed against civilian populations, whether or not they violated the domestic law of the country where they were perpetrated. This was revolutionary. Under traditional international law, a state could do almost anything to its own citizens. Sovereignty protected internal actions from external judgment. The London Charter destroyed that protection. It said that some acts are so fundamentally evil that they transcend national sovereignty. The defendants didn't grasp this. Their defense kept returning to German law, to orders from the German state, to the authority of the German government. They were arguing in a framework that the tribunal had explicitly rejected. And then the prosecution introduced evidence that made even those arguments impossible, because it turned out that the experiments violated German law too. Let me explain what I mean. The defense wanted to argue that they were following German legal and medical standards, that everything they did was lawful under German regulations. The prosecution destroyed that argument with a single document. In 1931, 15 years before the trial, the German government had issued comprehensive guidelines for medical research on human subjects. These guidelines, developed by the Reich Health Council, were among the most advanced in the world. They required informed consent. They prohibited research on vulnerable populations. They mandated that experiments must serve the public good and could not cause unnecessary harm. The prosecution entered these guidelines into evidence, and then they showed that every single experiment described in the indictment violated those German regulations. The defendants couldn't claim they were following German law because they had violated German law. They couldn't claim they didn't know better because the regulations were explicit. They couldn't claim the rules didn't apply during wartime because the regulations made no exception for war. Their own country's medical ethics rules condemned them. Quick reminder, if you're finding this analysis valuable and you haven't already, please take a second to like this video. It really helps with the YouTube algorithm and lets me know this type of deep dive content is what you want to see more of. All right, back to the story. By mid-1947, the defense was in complete disarray. Following orders rejected. To quoque rejected. Medical necessity rejected. Professional status backfired. German law used against them. Every major defensive argument had collapsed. So they tried one more strategy. A strategy that reveals just how disconnected they had become from moral reality. They argued that the victims weren't really victims, because they were going to die anyway. This argument appeared in multiple forms throughout the defense. Concentration camp prisoners were condemned criminals. They were enemies of the state. Many were already under death sentences. If the experiments killed them, it simply accelerated an inevitable outcome. Therefore, using them as experimental subjects caused no additional harm. Think about what this argument reveals. To make this case, the defense had to accept the Nazi state's categorization of millions of people as subhuman and disposable. They had to argue that a death sentence, whether legal or not, strips a person of all human rights. They had to claim that medical ethics don't apply to people the state has designated for death. The tribunal's response was unambiguous and became a cornerstone of modern medical ethics. The value of a human life is not determined by the state. A person under a death sentence is still a person with rights. Medical experiments require voluntary consent regardless of the subject's legal status or life expectancy. But there's something even more damning about this defense. Many of the victims weren't under death sentences at all. They were political prisoners, resistance fighters, people imprisoned for their ethnicity or religion, children. The defense's own argument was factually false. And when confronted with this, the defense made a revealing admission. They argued that the victim's legal status was irrelevant because the experiments served a higher purpose, advancing medical knowledge for the German people. This was the moment the defense destroyed any remaining credibility. Because what they had just articulated explicitly and on the record was that the ends justify the means, that medical research can supersede individual human rights, that doctors can decide who lives, who dies, and who suffers in the name of science. The tribunal took that admission and used it as the foundation for something revolutionary, a set of 10 principles that would govern medical research forever. These principles were written into the judgment itself. They became known as the Nuremberg Code. The first principle, the most fundamental, the one that appears before all others, reads, "The voluntary consent of the human subject is absolutely essential. Not recommended, not preferred. Absolutely essential." The code goes further. It specifies that consent must be truly voluntary, without force, fraud, deceit, duress, or coercion. The subject must have sufficient knowledge to make an informed decision. The subject must have the legal capacity to consent. And critically, the subject must be able to withdraw consent at any time. Every single one of these requirements was violated in the experiments described at trial. Every single one. And the tribunal made clear that these weren't new principles invented for this trial. These were fundamental medical ethics that the defendants had knowingly and systematically violated. The Nuremberg Code wasn't just a verdict on 23 defendants, it was a verdict on the entire system of medical practice under the Nazi regime. It established, in international law, that medical ethics transcend national sovereignty, that consent is not negotiable, that no state, no war, no emergency can justify human experimentation without voluntary agreement, The defense had walked into the courtroom believing their professional status would protect them. They left having created the legal framework that would forever define their actions as crimes. And then came the verdicts. August 20th, 1947. After 140 days of proceedings, 85 witnesses, and nearly 500 documents, the tribunal reconvened to deliver judgment. 16 of the 23 defendants were found guilty. 7 were acquitted, including Dr. Adolf Pokorny and Dr. Kurt Blom. The acquittals proved the tribunal was not rubber-stamping convictions. Evidence mattered. Individual culpability mattered. Where the prosecution failed to prove guilt beyond reasonable doubt, the tribunal acquitted. But for those convicted, the sentences were severe. 7 defendants were sentenced to death by hanging. Karl Brandt, Hitler's personal physician. Karl Gebhardt, Himmler's doctor and president of the German Red Cross. Joachim Mrugowski, chief of hygiene at the Waffen-SS. Wolfram Sievers, Reich business manager of the Ahnenerbe. Waldemar Hoven, camp doctor at Buchenwald. Victor Brack, organizer of the euthanasia program. Rudolf Brandt, Himmler's personal administrative officer. 5 received life sentences. 4 received prison terms ranging from 10 to 20 years. Some of these sentences were later reduced on appeal, but the death sentences were carried out. June 2nd, 1948, Landsberg Prison, Bavaria. The 7 condemned doctors were executed by hanging. Karl Brandt, who had stood in the courtroom 18 months earlier confident that his status as a leading physician would protect him, was dead. His defense, the strategy he and his co-defendants had believed would save them, had instead created the legal precedent that condemned not just them, but the entire concept of coerced medical experimentation. So let's trace the complete arc of defensive failure. Because what we've seen here isn't a series of random mistakes. It's a systematic cascade where each miscalculation made the next one inevitable. They misread the superior orders defense, not understanding that international law had evolved beyond that principle. When that failed, they tried to quoque, not realizing that comparative wrongdoing is not a legal defense. When that collapsed, they claimed medical necessity, not anticipating that their own documents would prove the experiments were both criminal and scientifically worthless. When the documents destroyed them, they relied on professional status, not understanding that medical training made their crimes more culpable, not less. They misunderstood the legal framework, preparing arguments based on German law when the tribunal operated under international principles. They assumed European legal culture would defer to state authority, not knowing they faced American judges applying a revolutionary new category of crime. They violated their own country's medical ethics regulations, making even domestic law arguments impossible. They tried to dehumanize the victims, arguing that condemned prisoners had no rights, and in doing so, they articulated the very philosophy the tribunal was designed to condemn. And finally, they created the evidentiary foundation for the Nuremberg Code, a set of principles that would define their actions as crimes against humanity for all of history. Each defensive strategy made the next failure more likely. Each miscalculation left them weaker for the next argument. By mid-1947, they weren't defending against the charges. They were cementing their own condemnation. So why was the Nazi doctor's defense so much weaker than they expected? The answer reveals something fundamental about the collision between professional arrogance and moral evolution. These doctors walked into the courtroom in December 1946 with assumptions rooted in a world that no longer existed. They assumed that state authority superseded individual rights. They assumed that medical professionals would defer to other medical professionals. They assumed that wartime necessity justified extraordinary measures. They assumed that legal precedent and professional courtesy would create space for acquittal. Every single one of those assumptions was wrong. Not because the tribunal was biased, but because the world had changed while they weren't paying attention. The Holocaust had revealed something that shattered previous legal and moral frameworks. It demonstrated that states could commit atrocities so systematic and so vast that traditional concepts of sovereignty and professional ethics were simply inadequate to address them. The doctor's trial was part of the international community's response to that revelation. The defendants were preparing legal arguments for a 19th century trial. The tribunal was conducting a 20th century reckoning that would shape the 21st century. The gap between those two realities made the defense's collapse inevitable. And here's what makes this even more profound. The doctors weren't just defending themselves. Whether they realized it or not, they were defending an entire philosophy of medical practice. A philosophy that said doctors know best, that medical judgment supersedes patient autonomy, that advancing science can justify individual suffering, that professional expertise creates moral authority. The Nuremberg Code destroyed that philosophy. It replaced it with something revolutionary. The principle that human rights in medical research belong to the research subject, not the researcher. That first principle, voluntary consent, is absolutely essential. It wasn't just a legal ruling. It was a complete inversion of medical authority. For centuries, the Hippocratic tradition had placed moral authority in the hands of the physician. The doctor decides what's best for the patient. The doctor determines the course of treatment. The doctor's judgment is supreme. The Nuremberg Code said, no, the patient decides, the subject decides. Consent is not something a doctor grants or withholds. It's something a patient or research subject possesses as an inalienable human right. This principle has become the foundation of modern medical ethics, every institutional review board, every informed consent form, every human subjects research protocol, every patient rights law. They all trace their lineage directly to the verdict delivered in Nuremberg in August 1947. The U.S. Department of Defense adopted the Code's principles in 1953. The United Nations incorporated the fundamental consent principle into the International Covenant on Civil and Political Rights, which declares that no one shall be subjected without free consent to medical or scientific experimentation. The World Medical Association used the Nuremberg Code as the foundation for the Declaration of Helsinki in 1964, which governs international medical research ethics. The defendants created the legal precedent that would define medical ethics for generations. They walked into the courtroom believing their credentials would protect them. They created the framework that ensures their names will forever symbolize the abuse of medical authority. But there's one more layer to this that we need to understand. The weakness of their defense wasn't just about legal miscalculation. It was about moral blindness. Throughout the trial, the defendants had opportunities to acknowledge what they had done, to express remorse, to admit that their actions violated fundamental human dignity. A few of the acquitted defendants may have benefited from showing some recognition of moral wrongdoing, even if they argued they personally weren't criminally liable. But the convicted defendants never did that. They defended, they justified, they rationalized. Right up to the moment of sentencing, they maintained that they were professionals following orders in service of a greater good. That moral blindness made conviction not just legally sound, but morally necessary. Because the tribunal wasn't just adjudicating individual guilt, it was establishing a principle that would echo through history. Now, there are some acts so fundamentally evil that no order, no authority, no professional status can justify them. The doctors expected a professional trial where expertise and credentials would matter. They got a moral reckoning where their expertise made them more guilty, not less. They expected deference to medical authority. They created the legal framework that subordinates medical authority to human rights. They expected to be judged as colleagues. They were judged as criminals. And that's the answer to our central question. Their defense was weaker than they expected because they fundamentally misjudged what was at stake. This wasn't a trial about medical practice during wartime. This was the birth of modern international human rights law. And they were on the wrong side of history at the exact moment history was being written. So those are the defensive failures that made conviction inevitable. Misreading superior orders, attempting to quoque, claiming medical necessity, relying on professional status, misunderstanding the legal framework, violating their own country's regulations, dehumanizing the victims, creating the evidentiary foundation for their own condemnation, and underlying all of it, a complete moral blindness to the fundamental humanity of their victims. Could their defense ever have succeeded? Most legal scholars say no. The evidence was overwhelming. The crimes were documented in their own handwriting. The victims testified. The legal framework had evolved beyond the defenses they could offer. But there's a deeper question. If these doctors had acknowledged guilt, expressed remorse, and cooperated with the tribunal, would the outcome have been different? We'll never know. What we do know is that their defensive strategy guaranteed not just conviction, but historical condemnation. The Nuremberg doctors' trial lasted 140 days. The principles it established have lasted for more than 75 years and continue to govern medical research worldwide. The 7 doctors executed in June 1948 believed their professional status would protect them. Instead, they became the foundation for a revolution in medical ethics that ensures their crimes can never be repeated under the guise of science. If you found this analysis valuable, I'd appreciate if you'd like the video and subscribe to the channel. I analyze wartime trials, international law, and the evolution of human rights using primary sources and court records. Drop a comment telling me which defensive blunder you think was most fatal to their case. Was it misreading superior orders, underestimating the evidence, relying on professional status, the moral blindness that ran through everything? And here's a question for you. If the defendants had acknowledged their crimes and expressed genuine remorse, could the Nuremberg Code still have emerged? Or was their defensive resistance necessary to create the legal framework we have today? Let me know what you think in the comments. Thanks for watching, and I'll see you in the next one.